So we're going to do a kind of modified panel on pretrial justice because we have three very knowledgeable prosecution leaders who have worked in the area of pretrial reform that I want you to hear from. And each of them has a lot to say about what's going on in their jurisdiction and what has happened as a result of their involvement in the pretrial reform movement. So what we're going to do is have them speak to you for 10 minutes each about what's going on in their jurisdictions. And then we have a typical panel, and I think will be a lively discussion about pretrial reform. So we have with us today Chief Assistant District Attorney Jay Boyarsky from Santa Clara County, California. You've already heard California has really just completed some very, very extensive pretrial reform, including the elimination of money bail. The elected district attorney in Santa Clara County, Jeff Rosen, who many of you may know, was instrumental in working on those issues. And Jay was an important part of that. Jay is pitch hitting for Jeff because Jeff has recently undergone surgery, but has a lot to say about what's happening in California and the role that the district attorney's office played in that. We're also delighted to have District Attorney Scott McNamara, who is a friend from Oneida County, New York. Scott was the former president, I believe last year, of the New York State District Attorneys Association. Bail reform in New York is a very lively issue, a lot going on. And Scott was instrumental and very involved in a lot of those discussions. He also has a great perspective of these issues from a small and rural jurisdiction and what's going on and what the challenges are in those kinds of jurisdictions that deal with other elected but not legally trained individuals who set bail. And then, last but not least, we have Commonwealth Attorney Tom Wine from Jefferson County, Kentucky. When I started working on these issues on a national level, the name everyone talked about was Tom Wine because he was one of the first district attorneys to use what has become known as the Arnold tool for pretrial assessment. But he has adopted these holistic kinds of reforms now for a number of years and can tell you about what their experience has been. Many of the reforms that Charisse talked about, I think, were modeled after some of the things that Tom was doing in his jurisdiction. So we'll begin with Jay. I know Jay has a PowerPoint that he's going to do, and then we'll move to the others. Thank you.
Denise just asked me to serve as a filler. So what Denise is referencing is that we have what I think is probably the world's largest online library of pretrial justice resources. Our website is pretrial.org, but we transitioned last year or 2 years ago to something we call the University of Pretrial. We call it UP. Please don't say UP, okay, because that's a sentence and it doesn't describe. Okay, this is a really tough room for jokes. Is this thing on? Wow. Okay. So the University of Pretrial offers webinars. They're free. We also have some online courses. We also have an in-person course happening in Las Vegas in November on the fundamentals of bail. So I can talk through a little bit more of those resources to anyone who's interested.
Good Phil. It's really an honor for me to be here. I want to thank the District Attorney of Salt Lake City, Sam Gill, as well as Chris Heyman from Center for Prosecutorial Excellence. It's really a privilege to be here, even though I am pinch hitting for Jeff Rosen. Many of you know he's doing okay. He tore his Achilles tendon completely, which is a pretty big rehab, but we keep telling him he'll be up and hopefully not playing any more tennis in the future. So I think the reason why Jeff was asked to speak on this panel is because Santa Clara County has had an independent pretrial services department separate from the DA, separate from law enforcement for over 40 years. And also because there's been this dramatic change in California where we just eliminated cash bail, which is rather remarkable. I mean, imagine if a state just said we're going to get rid of casinos. And I use that example because it seems to me that if you're running a bail bond business, it's about as profitable and about as much of a sure bet as running casinos. So there's going to be a lot of litigation over this bill, but it's rather remarkable that it passed. When I think about these types of big changes, it reminds me of what the police chief of San Jose says about cops. He says cops are really easygoing people. There's really just two things that they don't like. They hate the way things are, and they hate change. But other than that, there's just not a problem. And to hopefully a lesser extent, the same is true of prosecutors. But in Santa Clara County, we are very familiar with the Office of Pretrial Services, but we've always had a bail schedule and cash bail. I just have this interesting factoid that the first bail bond company was in San Francisco in the 1890s. It was run out of a saloon. They lost their bail bonds license in 1912 due to massive corruption, but they were able to keep their liquor license. So Cherise talked about sort of the history of bail and pretrial services, but I wanted to bring this slide with me, and it shows the frog sitting in a pot of boiling water. I've been a prosecutor for 25 years, and so I became a prosecutor at what many in California believed was the heyday of being a prosecutor, and that was when all the overly lenient sentences that were in place in the 1960s and 70s and the early 80s, all of that started to change. And we got rid of our 5-year lid on a ban on consecutive sentencing, and we finally developed one-strike rules for heinous sexual assaults. And instead of working toward family reunification, when it turned out someone in the home had been molesting all the children, we were now able to send all these people to prison. California seems to be the land of good intentions, where no matter what end of the political spectrum is, you're able to implement these good intentions, and then all the unintended consequences start to take effect. And so California, just a few years ago, had over 150,000 people in jail, whereas 20 years earlier, there were about half that many. Crime rates stopped going up, but the incarceration rate kept going up very high. 3 strikes law was passed in California because of the Richard Allen Davis murder of Polly Klaas. And then you saw many people who were serving life sentences for nonviolent offenses, and some of their strike offenses, which led them to go to prison for life, were residential burglaries. So now the pendulum is swinging back, and many of us are very concerned. Well, where is the pendulum going to swing back? Are we going to go back to an era of no accountability? And so now we have pretrial services reform. And as prosecutors, of course, we believe in the presumption of innocence, but when we authorize a charge, we believe the person is guilty. And so I think especially the lower down we go on our organizational charts, we like it when people are in custody because they're guilty. It's not really supposed to be that way though, is it? It's not. We also like it because we can get them to go to trial faster, and that makes things, we have better evidence, typically.
My colleagues here, I think 6 or 7 of us are here. And it was truly an honor. As part of being the president of the DA's Association, the president gets invited to a lot of high-level meetings, especially at the governor's office, and also our highest court in New York State is called the Court of Appeals, and the Court of Appeals has a Justice Task Force. And as the president, I was invited to go to numerous meetings with the Justice Task Force, and was accompanied by my good friend Chris Hammond. Through those meetings, it became very obvious to me that bail was a major issue. And honestly, I knew from my own background, I had been a prosecutor for 26 years, the last 12, the elected DA in Oneida County. I knew that they were onto something. And what I was really aware of was this, that as a profession, at least in the area that I practice, we didn't really take bail serious. And most training on bail consisted of, I don't know, pick a number. I mean, I know in my office, up until last year, there was an outline. Okay, if a person was charged with this type of crime, recommend bail between this number and this. And I just knew once I started going to these meetings and listening to presentations especially, and I know my good friend Cy Vance mentioned the Vera Institute. The Vera Institute presented at that. And I started to see, geez, there's things that we could do better. And as an organization, the DA's Association, it was something that we were looking at. But I said, you know, what can I do better? What can the elected DA in the 16th largest county in New York State, which is a very small jurisdiction, there's 250,000 people in our county, and I have 22 assistants. So I started to look at it. And I also, while I was looking at it, and I always try to remind myself, even when I'm in Salt Lake City, sitting before numerous people that I see on TV and respect, and to remember who I am and where I came from. And so, who I am and where I came from, I grew up on a dairy farm, and I was very poor growing up. And so I always try to remember what it would have been like for Scott if he was 17 years old and got arrested for petty larceny. Fortunately, I didn't, because I didn't want to deal with my father when I came home. But, and I also realized how I would not have been able to make bail, and should I be in jail. So I always try to go back to where I came from. And so that's what I started to do on a personal level. On the state level, one of the things we did, and we did with Chris's help, through our best practice in New York State, we had meetings almost monthly. And Chris would bring in different people throughout the state to talk about what they were doing. And I started listening to what other people were doing and stealing their ideas. One of the ideas, and I can't remember, I think it was Tony Scarpino that was doing it in Westchester County. He was making his ADAs justify the bail that they were setting. And I said, wow, that's a novel idea. I've been doing this for 25 years and no one's ever done that to me, nor did I do it to my assistant. So I went back home after that meeting and I said, what can I do? So what I did was I contacted our sheriff, and I told the sheriff, from going forward, I would like a report on a daily basis that tells me who was put in jail the day before and what their bail status was. Fortunately, in Oneida County, we do not put a lot of people in jail every day. As a matter of fact, as of just the other day, I know there was nobody in jail strictly on a marijuana charge. I think 5% of our population is pretrial that is strictly misdemeanor pretrial, only 5%. It's not a big number. So I didn't have a huge list to go through, but every single morning, someplace between 6:30 and 7:30, I get a list. And honestly, I typically, while I'm watching either the early morning news from our jurisdiction or the first half hour of the Today Show, I go through that list and I send text messages to my assistants if I see something that doesn't look right. I'm fortunate, I'm in a small jurisdiction, I can do that. Obviously, if I was Cy or Darcel, or my good buddy John Flynn from Erie County, which is Buffalo, I probably couldn't do that, but I do that. The next thing I realized that we didn't do was we did not actually look at the statute and use our statute as we should be using it. So in our statute, it actually says what we're supposed to consider, kind of like assessment tools. And I said, you know, my assistants aren't even asking the questions, let alone know the answers to them. So on the back of one of our forms that every assistant's supposed to use on every single case that they recommend bail, I put the statutory parts that are questions that they should know the answers to. So for example, family history, you know, obviously criminal history, and a few other things that I thought were important. I have a tendency to be very, I think we should help and do what we can to take care of the people that defended our country or do defend our country. So one of the things I ask is a person, a veteran. There's a lot of other questions that might not be in the statute, but I think are important. What type of job somebody has? Do they have a supervisory capacity? You know, is it important to them and to their employer that they're at work? But I put that on the back, and I forced my assistants to start asking those questions, and we implemented that program. Also, at the same time, kind of spinning in the background of all this was Oneida County was one of the very first counties in New York State outside of the major cities that had traditionally not had a prosecutor or a defense attorney in court in our local criminal courts at the time of arraignment. And as Denise alluded to it, in upstate New York, the town and village courts, you can become a town and village judge if you have a driver's license. You do not need a law degree. You do not need a college degree. And actually in our county, I think I have 2 judges who do not even have high school education. So I started to think to myself, what am I going to do about this issue? Because we're not even there. And in New York State, the DA does not need to be heard for misdemeanors and violations. So historically, that group of people was setting bail, and doing it honestly in a way to show that they could be tough on crime in their small jurisdictions. So we started to become more involved in that. I told my assistants I want them putting their input. When they hear something that's wrong, just don't look the other way. And we started doing counsel at first arraignment. In between all of those things, I've seen a dramatic reduction in the amount of people that we're putting in jail, and hence the number that's about 5% of the people in jail right now are there on misdemeanor or nonviolent felony offenses. So that's what we've been doing, and I think it's working. I mean, obviously our state is considering changing the law. Obviously that's what they do, and I'll abide by whatever they do, but I think until that happens, and I've seen it throughout the state, various DAs are doing a lot of things to make the system better and to make it more fair, especially to people that do not come from wealth.
Great, thanks.
Thank you all very much, and let me say first of all that I kind of come to this position as a prosecutor through an unusual set of circumstances. I started out as an assistant Commonwealth's attorney or assistant DA back in 1980, and worked also with the Attorney General's office for about 3 years. So I had about 10 years experience. I then got elected to the Circuit Court bench in Jefferson County, which handles felony prosecutions. And among those responsibilities included setting bonds. I did that for 15 years, and then went to the Kentucky Court of Appeals for 5 years. In 2011, I found out that the current Commonwealth Attorney was not going to run again, so I went home and told my wife that I wanted to run for Commonwealth Attorney, and her first question was, does that mean you have to resign as judge? And the answer was yes. Judges are nonpartisan, prosecutors are partisan. Her second question was, have you lost your mind? But I had a real heart for being a prosecutor, and so I did run and won the primary as a Democrat, which also surprised people. This is not a liberal or a conservative issue. Everybody thought I was going to file as a Republican because they thought I was very conservative. I filed as a Democrat because I've been a lifelong Democrat. So one of the questions that Denise asked us was, why did you become involved with pretrial issues? And so I wanted to give you that background because there are 3 different phases in my life that got me moving into this. And let me also say I was very fortunate. A lot of things were already in place. I was not so much the innovator as the recipient of a process in Jefferson County that was going to be important for us. But as a prosecutor, when I first started out, when we set bail bonds, and we were involved in the arraignment once someone was indicted, we would talk with the defense lawyer, and the question was, how much can your client make? And if the answer was $500, we'd agree to a $500 bond because we felt like people would come back to court. But over the years, that changed. And I think now we, in the last, when I started back, and even as a judge, the question was, what can't your client make? And that's what the bond was set. As a judge, I would set those bonds, and a lot of times, I have to admit, I set bonds out of frustration. We would have somebody who failed to come to court. We had somebody who asked for a continuance, or their lawyers asked for a continuance because they weren't cooperative. I granted continuance, and I said, by the way, I'm going to increase your bond. You're not complied with the conditions of release. So that was not the right answer. And when I came back as a prosecutor and began looking at the cost, what does it cost? In Jefferson County, it's $71 a day to keep somebody incarcerated, no matter what their crime. We just had a meeting of our jail policy committee where they even calculated the cost of booking. So whether you're booked for a low-level offense or you're booked for murder, it takes about 39 minutes, costs $300. And that's an important number because we had 35,000 arrests and people booked through Jefferson County Mental Corrections last year. And you can imagine if you could reduce that flow of people going in through the booking process alone, how much money the county would save. And it's important because a quarter of my budget comes from the county. If I can go back to the county and say, we're saving you money through this process, and the courts are saving you money, then I feel a lot better when I go and say, I need another prosecutor because unfortunately of our drug epidemic and what's going on. And the fourth reason why I got involved, and it started then, it's increasing, and it's many of you in jurisdictions like Kansas and Missouri, some others are seeing this, are the legal challenges, the due process challenges, the equal protection challenges that are coming about through the federal courts, and change is being forced upon us. So there are a number of the reasons there why I got involved. So here's what we're doing in Jefferson County, and there's a lot of stuff, and I have to tell you, it's a lot easier to talk about it sometimes than to see it actually taking place. But one of the things that started back in about 2009 was a jail policy committee where we had representatives from the two different prosecutors' offices. We have horizontal prosecution. County attorney handles misdemeanor offenses and probable cause hearings for felonies that then subsequently get waived to the grand jury. We take over as the Commonwealth Attorney's Office. So we have representatives from both of those. Representative from the mayor's office, representative from the administrative office of the courts, representative from the public defender's office. He and I co-chair this committee. Also members of the private bar. We also have representatives from the citizens, and we have representatives from the court clerk. We all meet and we talk about the issues and see how we can implement change within our system. Among those changes was an arraignment court process on a misdemeanor level, where an assistant county attorney and assistant public defender meet right away when someone is being arrested. So they reach an agreement. By the time they come in for arraignment, all of our arraignments are held within 24 hours of arrest. Most of them are done in 8 or less hours. They have a recommendation to the court that the court usually follows and moves those people through. And that was funded through the federal government. On our side, on felonies, every week, the corrections department sends me a list of people who are being held on bond of $25,000 or less, and that are Class D felonies, 25 years of punishment. We look at those and decide whether or not those individuals should be eligible for home incarceration. About 75% of those cases, our prosecutors send back to me and say, I have no problem with that. So we allow those persons to go into the home incarceration program, which gets them out of the jail, and it can be supervised at a much cheaper rate. We also have a rocket docket where individuals who are charged with felonies and are being held on any other offense except for sexual offenses or murder offenses. Our prosecutors work right away at the very beginning before the case is even indicted, and if an agreement is reached, they will also agree that those individuals can be released on some non-financial conditions or some lower bond that will allow them to be outside of the jail. The Administrative Office of Courts has started an administrative release program where misdemeanor and violations, a pretrial services clerk will make a recommendation that person be released, doesn't even go to the court. And I was there yesterday to watch that process, because we have a group of Armenian judges and prosecutors and defense lawyers asking how we do pretrial releases. And among the conditions are, it has to be a low-level offender, they cannot have any pending charges, and they can't be a danger to themselves or the other. One of the persons who came up who met all but the last, because she kept falling asleep during the interview, she was so intoxicated, they said, we can't turn you loose, so we're going to hold you for up to 8 hours. But that's another way. Another thing that we're doing is we're purging old warrants. You don't think about this, but persons who are out on traffic violations and they have an outstanding warrant, usually the bond is set at like $100 or $200. They get stopped for something, sometimes 5 or 10 years after the driving offense. Then they go in and they have to be through that booking process. So the thought process is now, if you manage to stay out of trouble for 5 years or 10 years, when you get a speeding ticket, you have to show up in court, it's probably not worth the time. The other thing is, and I don't know about your jurisdictions, but in Kentucky, the local prosecutors, the local jail, that's all our money is being spent. And if you're being held at $71 a day just to pay that $100 fine, the fine goes to the state. We don't get any of that money. So it's kind of silly for us to spend $71 a day to get $100 and send to the state. So that's a consideration. We also have a bail project that just started. And I think the Bronx maybe is similar to there's several other states that are starting a bail project. Just to give you an idea, since June the 1st when that project started, there have been 383 referrals. Of those 383, 280 were actually interviewed. 215 people bailed out. So a private entity is posting bail for these individuals. 18 of them are homeless individuals. They have a 94% return rate to the court. 3 were juveniles that were bailed out. 28 people who were bailed out did not return to court. So it's not a completely successful program. But overall, 87% of the people bailed out and returned to court. 36 of those bails have been returned. They put up $300,000 so far. They've got back $70,000. The majority of the clients resolved their cases with guilty pleas, and they did so with an amended charge. There were 4 court dates from the release to completion on average for those individuals. So there's not been a great big stall, and the bail project has proven successful. But what I think is important for us to remember, too, with the bail project is there's follow-up. When somebody is out, there's somebody that's making sure they're getting their treatment, they're going to the drug program, they're getting jobs. And so we're dealing with a population, quite frankly, that is not used to structure. And now we're providing some structure much more cheaply outside the jail than what we're doing inside. So I'm trying to check that out. I apologize. So we have a number of things that are going on in Jefferson County. The other thing I want to say is that Kentucky was the first state to outlaw bail bonds for profit. We did away with our bail bonds back in 1976. And it's interesting because we like to think we were enlightened, but I got the background story on it. It turns out that the governor candidate got sideways with the lead bail bondsman in Kentucky. And my guess is he was not going to support the governor candidate. So the candidate said, when I get elected governor, I'm going to put you out of business. Well, he got elected governor. And he went to the legislature, and at that time, the Kentucky governor did a great job controlling the legislature. Got rid of bail bondsmen, made it a misdemeanor offense to post bail. So we've been without bail bondsmen since 1976, and the system has not collapsed. So California, you're not going to be in trouble. There was some litigation, but the system has not collapsed. Thank you very much.
Thank you. So Dewan, we're also going to start with you on some of our questions, and I was wondering if you could talk about the impact of bail or detention on people of color, and you've done a lot to eliminate that. But what has been the impact of the reforms that you've made on people who are poor and people of color?
You know, that's a tough question. I also am involved in another project dealing with implicit biases. None of us like to think that we have biases, but we do. And it's all sorts of biases, whether it's for gender, it's for race, it's for age, it's for weight, weight, sorry, I've got big waist, I gotta worry about that. So we all have something there, and the question is, how do we allow that to influence us, and we recognize it, and how do we overcome it? So there was a recent abstract at Princeton University back in April of 2018 that showed that black defendants had a 3.6% higher rate of being incarcerated on bail and almost $10,000 more bail than white defendants. So there was also a showing that there's been racial bias between blacks and white, whether or not a black or white judge. They showed the same disparity. And we know that when somebody's incarcerated, even for a very short period of time, pre-trial, it has a tremendous effect on their ability. Obviously, they're not earning any income while they're incarcerated. So for a very short period of time, they usually lose their jobs. We have a process through the Pretrial Justice Institute that I serve on the board there, that 3 days count. In 3 days, you're probably going to lose your job, which means you can't pay your rent, which means that you can't pay your child support, which means you can't pay for your car. And so everything goes downhill from there, and the longer you're incarcerated, the more likely you are to re-offend. Well, who is it most likely that's going to be incarcerated because they can't afford bail? Persons who are poor. Who's most likely the person poor? Again, the reality is the persons in minority settings. So we know that there is definitely a problem there. And again, as I said, I know that bail bondsmen collect a huge fee. So again, it's disproportionate to people who are poor. If you're putting up 10% of a $5,000 bond that you don't get back, and $500 means a lot. There's studies all over this country where the average American family has less than $500 in savings. That's huge, $500. We also know, as I said earlier, that persons who are poor, I looked at UCLA that did a study for 4 years between 2012 and 2016, the bail bonds that were imposed were $92.1 million. I apologize, $19 billion was the bail bonds in Los Angeles, UCLA study. Of that, African Americans, or excuse me, Latinos, were posting 92.1 million, their percentage. African Americans 40.7 million, and whites 37.9 million. That meant that there was $13.5 billion of unposted bond. Almost $250,000 people over that 4-year period were not able to post bonds. Again, they're all people, primarily people who are poor economic status, people who are minorities. So I think it definitely has an effect. I think lots of things get thrown at us as prosecutors. In Jefferson County, 22% of our population is African American, 50% of the jail population is African American. Pre-trial. Unfortunately, as I said, it's easier to talk about it than to act it, than to sometimes enact change. The national average, as Sharice has just said, for pre-trial detention is about 60% of our jail population. In Louisville, it's 75%. So we're higher than the national average. That's great. A lot of issues for us in terms of how our system of criminal justice is perceived.
I appreciate all that work for sharing there. So now we're going to do a lightning rod because we have like 15 minutes left. DA McNamara, I recall from my days as a prosecutor that one of the biggest concerns that the law enforcement community had was making an arrest and seeing the person back on the street before they finished their paperwork. I constantly would hear that. We're just still doing our paperwork and the guy's back on the street. So what has been the attitude of law enforcement officers about pretrial reform, and do we have an answer to that question?
Sure, things haven't changed in these, trust me. Actually, some of the most difficult phone calls that I field are, how come the guy that raped my daughter is at home right now, and he's supposed to be in jail? So it's definitely a problem. It's not just a problem with the police, it's a problem with the public. And I wish I knew the simple answer for that, because unfortunately today, especially I think more so now with social media, people are presumed guilty and then instead of innocent. And so we spend a lot of time trying, at least I do, spend a lot of time trying to explain the system to people. and that people are entitled to bail. It's actually in the Constitution. There's actually an amendment that talks about it. I mean, it's usually how the conversation goes. And I think there's a couple things. Number one, I started doing podcasts. I stole the idea from Parit Barara, and I don't have as many as Parit does, but my son is a big podcaster in fantasy sports, so I said, you know, maybe this is an idea. The first podcast I did was about bail, because I think it's the most important thing that we can push out to the public. I was surprised how almost every news person in our jurisdiction watched or listened to it. I've got to look into this YouTube channel, because I think that's even better. I think it's important that we continue to do what's right. And what's right is that we explain to the public how the system works, we follow the rules, and we don't get tied up with the hysteria that sometimes comes about when certain people commit a crime. I know with the police it's much more difficult. I'm not telling anybody in this room anything that they don't know. You know, endorsements or opposition by police unions are huge, and they can change the outcome of an election. I believe, and I work very closely with the police, I believe that it's, and there was talk about this before, changing anything is difficult. But I do believe this, and I saw it when we started videotaping confessions. You have to be persistent and overcome the initial, no, this is wrong, we don't want it. And you start at the top and you just keep working. One of the things that I do is I have my assistants go and train the police, continuously explain to them and make them understand what we're doing, why we're doing it, and therefore, when they do arrest somebody, when they do put handcuffs on, the police officer knows that there is a likelihood, especially if it's a non-violent felony offense or if it's a misdemeanor, that we're not going to probably ask for bail. And they know that in advance, so they don't have any, they don't presume that this person's going to go to jail. So I think it's just working with them. I think it's being the leader in law enforcement. And I think it goes not just for the police, but in your own office. I think it's really important for the elected DA or the highest level, whatever, if you're appointed, you set the climate. And it's very important that you let the people below you know what your position is. And if they just think your position is something, then they might react a certain way. And so, for instance, when you're talking about bail, I let my assistants know that incarceration isn't what we're looking for. We're trying to figure out what the right disposition of the case is, what the right punishment is, what the right rehabilitation for that person is. And then I take it one step further. When I see them do something and I'm like, well, why, that's a little, I go and sit down with them. Why, can I ask you a question? Why did you ask for that bail? And I'm still surprised that some of them will look at me and go, well, I thought you wanted to make sure this person goes to jail. And I always say, did you ever hear me say that? And so I think it's the same thing with the police. We have to continue to work with them. We have to work with our assistants. We lead by example. We set the climate. And we also have to educate the public. And that is a change in our job, but I think it's a very important thing that we do. We have to educate the public and let them know how the system works and what they should expect.
Thanks. So Jay, you're on the hook for this one, but one of the most hard-hitting criticisms of prosecutors that I keep hearing is that prosecutors defend the current system of pretrial because it makes their jobs easier, and in particular, it puts pressure on people to plead guilty. That's what the criticism is. And so prosecutors then oppose pretrial reform because it would make their life more difficult. Is that a fair criticism, and what would your response be to that?
Well, I think I already sort of gave a confession and talked about my attitude about this. So on the one hand, if I'm being honest, I want to say that to a certain extent it is a fair criticism, but then I want to say that in Santa Clara County and on this panel and in this room, many of us are not supporting money bail any longer. I've seen so many criminal defendants say, I only pled guilty because I wanted to get out. And And sometimes I hear that, and they seem credible, and I feel badly about that, and then I think, well, in Santa Clara County, they could have pulled their time waiver and had a probable cause hearing within 10 days, at which point we would have put on witnesses and evidence that at least would have showed that there was probable cause that they committed that offense. I think when we as prosecutors are faced with this criticism, which I think is somewhat valid and somewhat overstated, we need to remember that we're not doing this to change the hearts and minds of defendants. We're not going to make these needed reforms and then be hoisted on the shoulders of parts of our community as heroes, with people skipping into court out of custody and making full allocutions and saying, yeah, I did the crime and I want to say thank you to everybody for letting me get out without having to post bail, but now I'm ready to surrender and start serving myself. Like, that's fantasy land. But so if the criticism is something like that, we're doing it because we think it's the right thing to do, and really, most importantly, it's going to advance public safety. I shouldn't say most importantly, because the fairness to those accused is also very important. But many of us became prosecutors who would protect the public. We don't want to see more victims. And if you see people who are posting cash bail, getting out and reoffending, hopefully moving to this system will decrease that from happening.
Thanks. So Charisse, a concern was raised here, and I hear this concern raised often, that with pretrial reform, there's a big concern that there will be another burden on prosecutors because cases get delayed, and the cases will be much longer, there'll be a lot of adjournments, that prosecutors will have to repeatedly keep showing up at court appearances and lose valuable evidence. So you've heard these issues raised before. So what is your response to some of these concerns?
So I'll just answer that question with data, which is that we don't have evidence that supports the notion that moving to a system that honors the presumption of innocence, releases people who should be not detained pending trial, manages to detain the around 10% of arrested population who should be detained pending trial, results in a full collapse of the criminal justice system as we know it today. The District of Columbia has been operating a system like this for about 25 years. 25 years ago, they didn't eliminate money bond in the District of Columbia, but they inserted one line in some legislation updating a statute that said the setting of money bond may not result in detention. And so if, in fact, a defendant is still in custody after 3 days of having had a money bond set, he or she gets another hearing before the judges. And it was very quickly realized that that was doubling the caseloads for judges, because most people who were arrested in the District of Columbia then and today are people who are poor and could not afford the bonds that were being set. And so the change resulting in moving to a system in which about 90% of people, about 89 or 90% of people in the District of Columbia are released pending trial. And we're not a dairy farm country court system in DC. We have, we're a small urban area, but we have big city crime. And about 90% of people are released pending trial. Well over 90% of people come back for court without picking up a new charge. And of the folks who do pick up a new charge, which is about 12% of folks, only 2% are picked up for a new violent arrest. So the results and the positive results of the reform in DC are significant. It is a fully functional court system that has preventive detention hearings. Those happen within a couple of days of the U.S. attorneys requesting those. And the process for trial in DC is not 10 or 15 or 20 times longer than it used to be. In New Jersey, what we're seeing at the first year of data from the court system in New Jersey, now you remember I told you earlier, almost 100,000 people out of 150,000 criminal cases were given a citation in lieu of arrest, so not even booked in. And if I could answer the question about why am I still doing my paperwork and the guys out on the street, I would actually ask a different question. Why the hell does the paperwork take so long? And secondly, why are you in the booking station? Why are you doing paperwork? If the person is actually somebody who is being able to be out pending trial, shouldn't you have been able to issue a citation in lieu of arrest and not have to come off the street? So we've really got to think about the ways we ask these questions, because they may not be the right questions. We're not seeing huge case delays. Now, as I said, you can't just implement some portion of reform without the rest of it. So they did speedy trial work and reforms in New Jersey. And, you know, it's a little bit like complaining about a new exercise routine, right? If your doctor's ever told you you needed to start exercising to get healthy, those first couple of workouts, they stink. The first few weeks when you have to get up at 5 in the morning and go to the gym before work, it's not the happiest, moments of your life, but over time, those habits become entrenched, and the new way of doing things becomes part of your regular life. So we're not seeing long case delays in jurisdictions that have implemented reform. And in fact, in many places, the number of guilty pleas hasn't changed either. So the concern that people will be out pending trial and they will demand their day in court, as opposed to taking a plea, I would ask the question, isn't it part of your right to have a day in court? We simply have moved to such dramatic volumes of plea arrangements because of the volume of the criminal cases. And so being able for you all to prosecute fully the cases and that you probably went to school in order looking forward to prosecute rather than driving on suspended licenses, urinating in public, or small burglaries. So I think it's an important part of the question, but it also means that you've got to look and see what the case processing reforms are that are needed in your jurisdiction as well.
Good. And so one last question is, to me, data plays an enormous role in looking at the need for pretrial reform. And so, I'd just like the panel to talk a little bit about how they have data either themselves or the court, and how we've heard a little bit about that. But from my perspective, if you don't have data about who is detained and the length of time and what the charges are and the demographics of that population and how many suffer from the mental illness, you really can't get a picture of what your pre-trial population that's detained really is. And that's critically important to see what the need is in your particular community. Anybody else want to comment about data and how they use it in the pretrial reform area?
Well, we do. The Administrative Office of the Courts and the Department of Corrections both give us those statistics, and they can tell us how long somebody's been in custody. They can tell us what bonds. And again, it's somewhat disappointing though. Last year we had 409 people at one time were in custody on a bond of $100 or less. It would have been cheaper for the county to pay that bond out and get their money back because they're paying $71 a day. So fortunately, 33% of the, or 67% of the persons who were coming through pretrial were released administratively or judges ROR. So it is picking up when we start looking at it. It's a dollar issue. And I think that makes a difference.